Yes, Mr. Copple. Sorry to have kept you waiting.
Good morning. There were a few issues I wanted to pick up from yesterday before I go to the statutory provisions which my lady referred us to this morning. Can I start with the Milburn case, which was raised by my lady yesterday afternoon? I've had it put on your bench. It's a recent decision of this court on the jurisdiction of the Ombudsman under section 26(6)(a), 28th February 2023. The point, I think the only point of relevance is in paragraph 60 of Milburn, where in the judgment, Justice Stuart Smith, with which the other two judges, including my lady, agreed, there is consideration of section 26(6)(a), and it is said that the intention of the statute is best achieved by giving the words of section 26(6)(a) their fullest reasonable meaning. Taking the lead from Lord Denning, which is a reference back to paragraph 57(2) and Lord Denning in the Bradford case, where Lord Denning was considering not just 26(6)(a) but 26 more generally. So, insofar as it matters in this case, the words of 26(6)(c) are to be given their fullest reasonable meaning, so as to produce a construction, said Lord Justice Stuart Smith, that ensures that the Ombudsman does not conduct an investigation which might trespass in any way on the jurisdiction of the tribunal. And you can substitute tribunal for court, so far as 26(6)(c) is concerned. There's never been an issue in this case about the breadth of construction to be afforded to section 26(6)(c). But insofar as the court wishes to have reassurance about that, then this is a relevant authority. Then section 12 of the Interpretation Act. My lady asked us to reflect on section 14 of the 1978 Act and also section 32 of the 1889 Act. And again, there are copies on your benches. If I could ask you to take up the 1889 Act provision. And this is in effect a consolidation of what is now section 12 and section 14. But what we would say section 32 highlights is that the power which is now in section 12 of the 1978 Act, which was in section 32(1) of the 1889 Act, is the equivalent for administrative actors of the power in section 32(3) of the 89 Act, now section 14 of the 78 Act, for legislative actors. So, legislative actors, see section 32(3), have an implied power, say where the contrary appears, to rescind, revoke, amend, or vary any rules, regulations, or bylaws which they may make. I say legislative actors as a compendious term, including rules and bylaws. They have the power to rescind, revoke, amend, or vary, and we would say that section 32(1) of the 1889 Act, as it then is simply the equivalent for administrative decision makers, the power to exercise a power or duty on more than one occasion, carries with it the power to withdraw, review, supersede the original exercise of the power. But it wouldn't have been appropriate to speak of rescinding or revoking or all the terms which are used in conjunction with legislation in section 32.3. So the powers have now been split out as between section 12, which is the equivalent of 32.1 and 2, and section 14, which is the equivalent of 32.3. But we do say that section 32 helpfully highlights that what section 12 is getting at, amongst other things, is an implied power to, I'll call it revoke, to review, withdraw, supersede, to retake a decision where an administrative actor has already exercised the power or discharged the duty.
Sorry, how does that come from the language?
Well, Lady, I made my submission on the language of section 12 yesterday, and it's the words: the power may be exercised and the duty shall be performed from time to time as occasion requires. And what it seemed to us the old section 32 highlighted was that was intended to do the same for administrative actors as rescinding, revoking, amending, or varying does for legislative actors.
I just don't follow that. You're saying that section 32.1 is to be construed as including concepts which are similar to the concepts which are expressly provided for in section 32.3. Is that the point?
Yes. Yes.
Right, let me just write that down. All right. Well, I have your submission.
So that when an administrative actor re-exercises, looks at a matter again, takes a different decision, that carries with it the overtaking, the superseding of what was there before. But it wouldn't be necessary and wouldn't be appropriate, we would say, to speak of rescinding, revoking, amending, or varying as is done for legislation.
Might there be another word, another word with an analogous meaning that might express a similar idea in relation to administrative actors?
There may have been. I'm not. It wouldn't be impossible to think of one, but one does have to ask: what are these two provisions doing in the same section, in section 32, if they are concerned with different things?
Okay.
So, and there are undoubtedly circumstances, and one sees them in the case law, where an administrative decision maker changes their mind, proposes a local plan, and then decides to withdraw it. Now, there's no express power to withdraw the decision, but it's implicit that you can look at a matter again because your powers and duties subsist and can be performed from time to time as occasion requires. And the only real issue then, we would say, is whether the contrary appears from the context, from the other provisions of the legislative scheme, that an administrative decision maker should not be permitted to look again and change their mind.
I mean, as I understand it, the argument really against you is that whether it's this section or the contrary appearing, or because it's quasi-judicial, once you've issued the report, you're a bit like a court, and therefore the contrary appears if it is section 12, or the scheme of the Act is that you don't have the power to withdraw the final report.
Yes. Absolutely. And the answer to that question lies in an analysis of the statutory scheme and a comparison of the Ombudsman's powers and duties with those of judicial actors, other administrative actors whose powers and duties have also been considered by the courts. So I had intended to show you, and I will show you very briefly, just another example of section 12 being used in the context of revoking a decision. There are, slightly undersold section 12 yesterday, there aren't many examples in the authorities that you have in the bundles of section 12 being invoked. There are a good many others in the case law, but one with just an example, which I've handed up, is the Welsh Language Commissioner against National Savings and Investments. As if his Honour Judge Jarman had not already figured prominently enough in this case, he also sat in this judicial review, which had the notable feature of having been conducted in Welsh, paragraph 4. The issue in the case was whether National Savings and Investments, a Crown body which was entitled but not required to adopt a Welsh language scheme, how it would deal in Welsh with its Welsh-speaking customers, whether National Savings and Investments had a power to revoke that scheme once it had been adopted. And the claimant in the case, the Welsh Language Commissioner, argued that NS&I didn't have the power to revoke, and that there was no express power in the relevant act to do so. And paragraph 50 of the case, having made submissions on the statutory scheme generally, counsel for NS&I relied upon section 12 of the Interpretation Act, and section and paragraph 51 is the divisional court upholding NS&I's submissions, that it did have a power under the statutory scheme to revoke its Welsh language scheme, and one sees about 8 lines up from the bottom of 51, we consider it quite clear that the statutory regime is as Mr. Jones contends. Such a body, a Crown body, retains the ability to dictate the contents of the scheme, including whether or not to maintain a scheme in the future, although of course in the light of the suggestions and guidance given by the Commissioner. And whilst we do not consider it necessary to rely upon it, because we consider the wording of the statute is sufficiently clear without, we know that section 12 also supports Mr. Jones' and this case is typical of the way that Section 12 is used, and indeed the way that it perhaps figured in the judge's thinking. In this case, it's supportive of the power for which the Ombudsman contends, but one could reach that power, imply that power if necessary, without reference to Section 12. The authority that you do have in the bundle, where Section 12 is explicitly invoked, is in the context of arguments about functus, is the decision of Mr. Justice Fordham in the Johnson case, Bundle 1, Tab 11. I'm not going to take you through that case, but I just wanted to draw your attention to paragraph 36 of Johnson, Tab 11. It's page 272 of Bundle 1.
Sorry, para.
Para 36.
Thank you.
Where Mr. Justice Fordham, having applied Section 12, decided that the contrary did appear, notes that he'd been referred to a passage from Wade and Forsyth, also cited in Dickens, which you have, and Demetria, which you have, which said of Section 12 of the 1978 Act that it gives a highly misleading view of the law, where the power is a power to decide questions affecting legal rights. In those cases, the courts are strongly inclined to hold that the decision once validly made is an irrevocable legal act and cannot be recalled or revised. The same arguments which require finality for the decisions of courts of law apply to the decisions of statutory tribunals, ministers and other authorities. No, I don't...
Sorry, so I don't understand this quotation. So the authors of Wade and Forsyth are saying that Section 12 gives a highly misleading view of the law.
Yes,
That's what it's actually said.
A little unusual to say that a statute gives a
Bizarre.
highly misleading view of the law, but
That's
they're very learned, and I think the point that's being made is that where a decision determines legal rights, the contrary will usually appear. So don't be deceived into thinking that it's going to be a normal event. But the point I get from it is to say, well, that's fine for legal rights, and I don't dispute that, and I don't have to dispute it. We're a case which doesn't concern the determination of legal rights, and in that context, the learned authors don't seem to think that.
But the statutory scheme does entail legal consequences at various stages, doesn't it?
Well, it entails legal consequences as to the duties upon an authority to consider the contents of an ombudsman's report, and if they don't agree with his recommendations, there are consequences for the ombudsman in terms of what he does next, and for the authority ultimately if they still don't agree in terms of publishing a notice to that effect. But perhaps I'll make a point now that I was going to submit in this paragraph 85(3) of the judgment below. The judge accepted my submission that the Ombudsman does not. Page 152 of the core bundle. The LGO does not determine legal rights. She refers first of all to section 28(4), and I don't think you've seen that. It's in paragraph 10 of the judgment, or page 708 of bundle 3. Section 28(4) states that the conduct of an investigation shall not affect any action taken by the authority concerned or any other person or any power or duty of the authority concerned or any other person to take further action with respect to any matters subject to the investigation.
So that's the conduct of the investigation. It's a completely different point from what the consequences are of issuing a report. Well,
the conduct, we say, and the consequences of the investigation, so the findings pursuant to an investigation. But I mean, what I rely on section 28(4), but I also just point to sections 30 and 31 in terms of the consequences of a report. The Ombudsman makes recommendations. The authority then decides whether or not to give effect to those recommendations, and it doesn't have to. We expect that they usually will, and they usually do, but there's no obligation, no formal obligation to, and it's simply not right to say. And I'm not sure that it even has been said by the appellant. It's not right to say that the Ombudsman determines anyone's legal rights.
That's not the point I was putting to you. I mean, the point I was putting to you is that the issuing of a report entails legal consequences because, for example, it imposes a duty on the local authority.
Yes, it imposes a duty to consider.
Well, does it? I thought you were submitting that the council can say we're not interested in what the Ombudsman says. Maybe improbable, but as a matter of legal consequence, that the council are entitled to say this doesn't impose any legal obligations on us.
Yes. So, section 31(2) says the report shall be laid before the authority, and it shall be the duty of the authority to consider the report. So there is a legal duty to consider, but that doesn't affect the claimant's legal rights. So I accept legal consequences, see section 31, and the procedure that must be followed after the report is published, but not determination of legal rights.
Can I just ask whether legal rights is too narrow? Because obviously a prisoner subject to licence is a prisoner subject to licence, whether they're released or not. Obviously it's particularly important for them, but their legal status doesn't change. They're a prisoner subject to licence under life imprisonment.
Well, whether they're out on licence or not will have considerable implications for their legal rights, if not their precise legal status, but they will of course have freedoms of movement, etc., which they wouldn't otherwise have. And this case is certainly an example of how an ombudsman's report doesn't determine legal rights. The recommendation made to the authority in the August 2019 report was that they go away and consider exercising their discretion. That didn't confer a right on the claimants. Even it was only a recommendation, and even if it had been a duty or a requirement, it was only to consider. So It also doesn't help my learned friend, and I'll make the point now slightly out of order, but it doesn't help my learned friend to say, well, local authorities are expected to loyally follow the findings of the Ombudsman. See the Eastleigh case. Very unusual circumstances in that case, where the administrative court had said, yes, I agree that this report is legally flawed, but I'm not going to grant any relief because the authority can simply publish a statement saying we don't agree with it, and that's a sufficient remedy in itself. Court of Appeal then says, well, we can't have local authorities simply engaging in a publicity campaign with the Ombudsman. If the report is legally flawed, then there must be judicial review. But the findings, and I'm not going to go too far down this particular rabbit hole, but the findings in Eastleigh are wholly explicable, given the context. But they're also, insofar as local authorities are required to loyally abide by the Ombudsman's findings, they refer to his findings of maladministration, if such findings have been made, not to his recommendations. And there is a statutory scheme in section 31 for which governs the legal force of the recommendations, not all of which was in force at the time of Eastleigh. So, not a case of determination of legal rights. Can I then turn to and go to the beginning of my submissions on the power that the Ombudsman invited the learned judge below to imply, and which we say that this court should uphold, and that is a power of review to correct material mistakes of law, but only where there are compelling reasons to do so, and of course subject to the supervisory jurisdiction of the administrative court. And I make those qualifications advisedly and in line with paragraph 45 of Demetrio, tab 27, page 614. And I say that the power that we see, in addition to what the authorities acknowledge as a power to withdraw arrears in cases of fraud or fundamental error of fact, we say the extension of that of those existing circumstances is very unlikely to open any floodgates. The usual position is that the Ombudsman has a very broad discretion to define what constitutes maladministration in any particular case, subject only to rationality review. It is extremely unusual that the Ombudsman would be delving into legal matters to the extent that his decisions or reports raise legal issues in respect of which he may have fallen into legal error. And that ought not to have happened in this case either. See my submissions from yesterday. So this would be a modest extension of the well-recognised circumstances, and most recently, I think, recognised in the San Bertin case by the Court of Appeal, paragraph 3 of the judgment of Lord Justice Peter Jackson, bundle 1, page 212. I'm not arguing, as seemed to be argued in that case, see paragraph 4, for a power to review simply to take a different view of the same facts. I'm not arguing for any wider power of review or for a power of review which must apply to any other administrative actors who are subject to different statutory schemes, including other ombudsmen. I'll come back to other ombudsmen a little later. Paragraph 74 of the learned
So just before you move on from Samberton and what you describe as the well-recognised circumstances by which I understand fraud and mistake, is Section 12 the juridical foundation for the ability to reopen in those cases?
Well, I think I said yesterday that it may be. I didn't commit myself. We had been proceeding on the basis that the fraud and fundamental mistake of fact were limitations upon the common law doctrine of functus. So, had this been a case of, say, fundamental mistake of fact, the claimant would have had no claim or no argument. But I do see, as I think I have.
Well, I'm sorry, I'm having trouble following that, because we're not here concerned with common law powers. We're here concerned with statutory powers. So, to describe fraud and fundamental mistake of law as common law limitations on the doctrine of functus doesn't really tell us why in this context the statutory powers of a tribunal or an administrative body would be subject to that.
Yes, well, you're quite right. In the putting it into a statutory context, I think the point would be that Parliament could not have intended to preclude an administrative actor from reviewing a decision already taken where there has been fraud or fundamental mistake of fact. One could put that as a Section 12 Interpretation Act point. The contrary will never appear where there is fraud or fundamental mistake of fact. Or, as in some of the authorities, one could just proceed from implication from the existing statutory scheme without reference to Section 12. But it must always, as I think you're pointing out to me, it must always come down to what Parliament intended in the legislation.
That's the same. The either or you're positing is, in a sense, the either or that we're grappling with in this case. Either you start from Section 12 and say, does a contrary intention appear, looking at the statute, or you ignore Section 12 and say, well, what is implicit in the statute anyway?
Yes.
Yes. And it obviously does, or might have a bearing on the result, because one's talking in one case of a rebuttable presumption and in the other of a freestanding implication from the statute.
One is technically asking different questions, I accept, but the key part of the answer to the question will be whether the contrary intention appears, and if there's enough in the statutory scheme to preclude the power from arising, and if it's a case of where legal rights have been determined, then that may be enough. Although, again, not in cases of fraud or fundamental mistake of fact.
So is your submission that actually Section 12 doesn't matter at all in this case? It's the same question looking at the Local Government Act, namely, is it implicit that there is or is not a power to revoke?
Yes, I do say that. I know I do rely on Section 12, and I did before the learned judge. But if for whatever reason you don't think that Section 12 is applicable, then I do say the same point arises as it did in a a number of the authorities that you have in the bundles without reference to Section 12.
Thank you.
And what legal rights do you say were being determined in Samberton? Because they hadn't actually made a final decision that he was eligible. They just said, you're provisionally eligible, but you should go to another local authority. The other local authority says, not us. And then they say, now you're not eligible. But they haven't said you are getting the support.
Well, I think the reasoning in Samberton was that the decision that the claimant was eligible, which Brent sought to describe as a provisional decision, wasn't a provisional decision at all. It was a final decision which determined his eligibility. He was eligible, and therefore the only issue was whether Brent or some other authority was going to give him the benefit which flowed from that statutory right to assistance.
Thank you.
But that's a case which also turned and may indeed primarily have turned on the construction of the legislation in the sense that there were explicit powers of review for decisions which were unfavourable to a claimant, i.e. not eligible, but no power of review, no express power of review for decisions which were favourable. See paragraph 29(1) on page 219. So the factors set out by the learned judge in paragraph 74 we endorse as a list of relevant matters to be considered in performing the exercise of statutory construction. It's a list of factors which is drawn from the case law. The legal rights, I mean, she puts it as whether the function in question determines or impacts upon substantive rights, 74.4. An example of that, which just to give you the reference, is the Gleeson case. That's a decision. That's an administrative decision to grant planning permission. Bundle 1, tab 15, paragraph 24 and 25 at 367. And a stricter approach is taken in that context compared to a context where there is no determination of or impact upon substantive rights. See in the planning context the trustees of the Lake District case, bundle 1, tab 14, paragraph 37 at 351. I'd also add a footnote to her factor 9 at the top of page 150 of the core bundle, which was the extent to which attaining finality is of particular importance in that context. And we would say that is closely, the significance of finality is closely linked to whether the decision determines or impacts upon legal rights. And there's a much greater call for finality where legal rights are have been determined than when they haven't.
Isn't there a need for some finality in this context? I mean, you've had, I forget how many iterations of the report, it's 5 or 6, and then a challenge is intimated, and you turn around and go, oh, actually, let's have iteration 6 or 7, whatever it is. I mean, it could go on forever, couldn't it?
Well, my lady, I fully appreciate that the facts of this case are perhaps not the best, or aren't the best background in iterations in relation to finality, but in the normal case, we wouldn't have had so many iterations, and we go straight to a statement of reasons or a report. But Milady, on
just
final,
following up on that point, given the Ombudsman's wide powers to regulate his own procedure and the very sensible procedure he's adopted of having sending draft reports to the parties for their comments, why is there any need for him to have a power to revoke for legal error? Because surely one can expect that in most cases those sorts of points will be flushed out by the iterative process that precedes the production of the report.
So two points, I think. Yes, you're right, and that leads to the conclusion that we would say that the power to review in these circumstances will only be exercised in quite unusual cases. But secondly, the process for draft decisions and draft reports and seeking representations from both parties, it can, and indeed it did in this case, perhaps have the opposite effect from what it would be intended to do, which is to provide clarity to the Ombudsman, because of the tenacious and committed legal representations which were made on each iteration, and added to the burden on the Ombudsman in terms of deciding legal matters. So it is a power which we say is needed, but will only be needed in unusual cases.
Well, how can we have any confidence it will only be needed in unusual cases? I mean, you simply can't tell, can you?
Well, what I said a few moments ago is that the Ombudsman doesn't usually determine legal issues. And perhaps I'm only...
Maybe that's where it all went wrong.
Well,
indeed it went wrong.
Well, indeed, that's my submission.
Yeah.
I do say that's where it went wrong, and that the February 2021 report got to the right conclusion in the end.
Yeah.
But along the way, the Ombudsman did purport to determine legal issues, and he did so in a legally erroneous way.
Yeah.
Now that's an unusual case, but it is a case where this limited power is necessary.
Because your basic submission about section 26(6)(c), as I understand it, is that the Ombudsman shouldn't have gone anywhere near this dispute once he'd clarified that it was a dispute about whether or not there was a power to do something.
Well, that was my submission on that the February 2021 report reached the correct conclusion, which perhaps ought to have been reached. Well, in fact, was initially reached on consideration of the complaint. See the first draft.
Yeah.
First draft decision. But that's not to say that, again, the fact that I'm not asking for a power which will be exercised in very many cases doesn't mean that the power ought not to be there. And I would reiterate that what I'm asking for is a relatively modest extension of the power which we say undoubtedly exists to review for fraud or fundamental mistake of fact, and a power that we do exercise and have exercised for many years in relation to mistakes of fact. So my lady asked me about finality, and the judge did address the question of finality in paragraph 87 of her judgment at page 153 of the core bundle. and she points out that in the third and fourth, fifth sentences, she points out that we're not actually talking about finality, or finality would not be achieved by concluding that the Ombudsman has no power to review. What would have had to have happened, and what the claimant says should have happened, wasn't finality. It was that there would have to be a judicial review of the Ombudsman's decision to set it aside. Now, in this case, one happened to have a committed local authority which was prepared to bring a judicial review and has brought a judicial review. But in lots of cases, whether a judicial review will be brought or not is much more difficult to predict, and claimants may not wish to incur the expense and difficulty of judicial review. Local authorities likewise. The learned judge held, and we endorsed, that the Ombudsman can't apply to judicially review his own report. He can't be both claimant and defendant to a judicial review. So then it's simply happenstance to a large extent whether a report which the Ombudsman reasonably believes to be legally flawed gets to be set aside or not.
Can I just ask on that, on the procedural aspect? Plainly, you wouldn't have reviewed the report if the local authority hadn't written to you, because you'd done your report and they'd have been happy and no one else would have raised a complaint. But once the local authority did write to you and say, look, it's all these flaws, then there would be nothing for you to stop you saying, actually, we're right, you're right, we'll agree a consent order to quash, notify the other side as interested parties so that they can object. And actually, it's not very much more. And you don't need this power to withdraw a report. What would you say about those procedural points?
Well, my Lord, absolutely. In this case, you're absolutely right. There would have been a judicial review if we hadn't withdrawn the report. There would have been, and we'd have been before the administrative court because the claimant would have, because Mr. Hunter's clients would have objected to a consent order being made, and we'd have had a judicial review, but with the parties sitting on different sides of the court. But my point is, in most cases, in many cases, one simply cannot be sure that a judicial review would be brought.
Well, that might be an incentive to get the law right in the first place.
What's more, if Mr. Hunter's right in relation to the report itself, it's a judicial review which would have put an end to the matter. Found there was nothing wrong with the August report.
My lady, there.
Well, what I'm finding difficult to imagine is a situation in which the Ombudsman has an iterative process. He considers submissions from both sides. He produces a report, and then all of a sudden he thinks, "Oh, my report is legally flawed." He won't come to that conclusion in the real world unless one or other of the parties has said, "Your report's legally flawed," and in that case, there's going to be a judicial review, isn't there?
Well, that may happen, and did happen in this case. There are other circumstances in which the Ombudsman may come to appreciate, for example, a judicial decision. There are other circumstances in which he may come to appreciate that. And of course, even where a judicial review is threatened, that doesn't mean that it'll be followed through, and the report will be able to be quashed by the administrative court. But it's putting the right course of action, really at the mercy of appetite for litigation of claimant
But your
and local
solution
authority.
usurps the jurisdiction of the court, because you're not even saying the Ombudsman should have a power to set aside a report if it's legally flawed. You're saying if he reasonably believes it's legally flawed, and that doesn't provide great confidence seen against the history of this case.
Well, Lady, it doesn't usurp the jurisdiction of the court, because as the learned judge held in paragraph 88 on page 153, if a report is withdrawn and the party who previously had been favoured by that report objects, then they have the right to judicially review, and we end up with a case like we actually have had in these proceedings. So, and the learned judge considered in some detail whether the Ombudsman's concerns about the report were well founded, and my lady, it didn't take you very long, I'd say, to identify, for example, the non sequitur in the report, which was one of his principal concerns. So, lady, this is an unusual case, but and the power would not be exercised in very many cases, but it is not terribly different, and is only a modest extension, as I've submitted, of a power of review or fundamental mistake of fact, which is another factor, a public law ground of challenge, which one might equally say, well, that's for the administrative court to decide. Error of fact is a standard public law ground of challenge, but that's not what the law says about errors of fact. So what's the difference?
Well, there's quite a big difference between a fundamental error of fact, where there's an undisputed objective fact out there in the world that the Ombudsman has ignored, and a power to review when he reasonably believes he's made a legal error. Well, I'd say there's a big difference.
Well, there's no difference in terms of they're both matters which could be said to be within the jurisdiction of the administrative court, and the administrative actor has got no business preempting the view of the court. But the law has taken the view on fundamental mistake of fact that it is better for the decision maker to correct his own mistakes rather than to depend upon the administrative court taking action.
Well, where that's undisputed, but what about a case of fraud or fundamental mistake of fact where there's an issue as to whether there's been any fraud involved? Let's take fraud, for example. Is it for the decision maker, the Ombudsman, to decide that he reasonably believes there's been fraud and therefore to revoke? Or is it not a question which determines whether or not the decision maker is or is not functus? There has to be a decision as to whether there has or has not been fraud, and ultimately that's a legal decision for the courts.
Well,
in other words, is it actually right to say that in cases of fraud or fundamental mistake of fact, there is an implied power to revoke on the basis that the decision maker reasonably believes that to be the position? Or is it not rather that there's only a power to revoke if that is in fact the position? Now, if it's undisputed, the decision maker can do it. But if it's disputed, that will have to be decided by the court.
Well, my lord is certainly right that where it is disputed, the matter may end up in court, and the court will decide. But whether it's disputed or not, it is a well recognised, I'll call it an exception to functus. See Sambertine. Most recently, there are other cases we had before the learned judge which which I think were cited in San Bertine on the same issue. But it is so if this case had been a case of fraud, wasn't, but if it had been a case of fraud, and the fraud had come to the attention of the Ombudsman, so in the council's letter they made well-founded or what the Ombudsman considered to be well-founded allegations of fraud, then it would be open to the Ombudsman to review and to issue a further report.
But not on the basis that he merely reasonably believed there was a fraud. What I'm edging towards, I think, perhaps is obvious, is that cases of fraud or fundamental mistake of fact are not analogous to the implied power that you're here contending for. You're here contending for an implied power to revoke, not if it is legally flawed, but if the Ombudsman reasonably believes it to be legally flawed. The more I think about it, the more likely I think it is that in cases of fraud or mistake, there isn't any such implied power, simply if there is a belief that it's been procured by fraud or by fundamental mistake. It must actually have been so. If undisputed, fine, but it's not the Ombudsman who is the decision maker as to whether there has been fraud or fundamental mistake.
So, my Lord, I think I'm in danger of repeating myself. I do agree that the Ombudsman may not be the ultimate decision maker because the matter may come to court. But if there is, as we say, there is an exception to normal functus principles where there has been fraud, then the decision maker who has taken the initial decision must then be the primary decision maker, and in practice must reasonably consider, must be satisfied that there has been fraud before changing his mind. Now that may be challenged, and the court may be the ultimate decision maker, but the administrative actor doesn't say, "Oh, we think there might have been fraud. We'll have to go to court about it." They're entitled, and that's the reason why there's an exception. They're entitled to revoke and reissue.
No, but in that case, if the Ombudsman says, I think there has been fraud, I'm going to revoke, and that's then challenged, then when the court says, if it does say, there was no fraud in this case, the consequence is that there was no power to revoke. He was functus, whatever he thought or said at the time. So the question of whether he's functus is not simply dependent on the question of the view that's taken by the Ombudsman, whereas in this case, you are contending that the question of functus is determined simply by the reasonable belief of the Ombudsman.
I do see that distinction. I say it's not a very significant distinction in practice. And of course, this is a case where I've submitted not only did the Ombudsman reasonably consider that the report was legally flawed, but that it was actually legally flawed, and I think this court will proceed to decide that. And then
But one of the difficulties that your test poses for a judge and posed for this judge is that she thought the application of the test required her to decide whether or not what the Ombudsman believed at a particular time that he'd exercised his jurisdiction under section 26(6)(c) or hadn't. It just isn't the right question at all, so it's apt to cause all sorts of chaos. Anyway, don't worry.
yeah, no, I accept she did inquire into what the Ombudsman believed in her view. I say she got that wrong,
Yeah, but she got it wrong because she was led up the garden path by your test, I would tendentiously suggest.
Well, she got it. We say she got it wrong on its own, on her own question at the end of the garden path, because there was good contemporaneous evidence that is what the Ombudsman thought.
Can I just ask a question that's slightly at a tangent? In paragraph 3 of his judgment in, how do you pronounce it, San Bertine or whatever, Justice Peter Jackson refers to Dago and Porteous. Is either of those two cases in the bundle? I find it incredibly difficult to navigate this bundle because it's not arranged chronologically. It appears to have been arranged in the order in which council thought they were going to refer to the authorities in their submissions, which is helpful for council but not at all helpful for the court.
Yes, maybe I'm sorry about that. They aren't in this bundle. I believe that Porteous was before the learned judge. We can provide both of these.
Well, I think that would be helpful. Very helpful. We don't even know at what level those cases were decided.
Well, Porteous was Lord Justice Mantell, wasn't it, on the? But there's not much reasoning about the error of fact. It was Court of Appeal level.
Well, anyway, perhaps you could provide those to us. That would be helpful. Yes. Whilst we've blown you off course, can I ask a related question? Coming back to section 30 of the Act, which is where we find the duty to prepare the report. Now, the report we're here talking about is a final report. A draft report, such as we had in this case, am I right in saying, is not what's here being concerned with. It might be in the form of a draft, it might just be in the form of a letter. So this is what I'm minded to find. It's simply part of the iterative investigative process. So for a section 30 report, let me call it a final report for clarity, the Ombudsman has to have completed the investigation. If there's a power to revoke and then continue, then ex hypothesi, the Ombudsman has not completed his investigation. So how is that consistent? How is power to revoke consistent with section 30?
So we say that once a report is revoked, then section 24A(6) kicks in again. Pardon me, so that's 683 of the
No,
bundle.
but I'm sorry to interrupt you. I'm focusing on the point of time before it's revoked. When the final report is issued, if your submissions are right, the Ombudsman has not completed his investigation. It's capable of being reopened and reconsidered. And yet the power, indeed the duty, to issue a report only arises on completion of the investigation.
Yes, and well, it's really the same point. The Ombudsman takes the step under section 31 on the basis that he has completed his investigation. Pardon me. Something then comes to his attention, let's say fraud or fundamental mistake of fact. Something that then comes to his attention, which leads him to think that he needs to revoke the report and to continue the investigation. But it's a revisiting and a re-exercising of a revisiting of the decision which is taken under section 31. The investigation continues, and then there is a re-exercising of the section 31.
So we should read section 31 as if it says, if a local commissioner thinks he has completed an investigation. Or it may turn out that he hasn't.
Well, I mean, I think that's that's what it must mean, even regardless of my arguments. I mean, he's got to, regardless of questions of punctus, the Ombudsman, in any case, has to reach as a view as to when his investigation is completed, but it's his view, and then proceeds to issue either a statement of reasons or a report.
So the power to revoke a final report carries with it the power to reopen the investigation on your submissions, is that right?
Yes, because Section 24. So once the step taken under Section 30, subsection 1 is revoked, Section 24A6, then, well, I mean, it continues to apply, and the investigation can be continued. Just as if there are fundamental factual matters come to the Ombudsman's attention, he will reopen his investigation and take proper account of those factual matters.
Thank you.
Just to follow up on Dago and Porteous, are there any other cases which support this power to reopen for fraud and fundamental mistake of fact?
Lady, I can't now recall, but I will check. Again, it hasn't been an issue between us as to whether there was that or there were those exceptions. So it hasn't been gone into in quite the same detail as other points. But I will check.
Thank you.
Thank you. We've blown you off course a little bit.
Yes. So I think I was on. I'll try and take this a little more quickly now. But I was on the judge's factors in paragraph 74.
Yes.
I was on finality, and I was simply going to make the submission that finality is of greater importance where rights have been determined as compared with where they have not been. And in our skeleton argument at paragraph 23, we suggested an additional factor which was of significance in a lot of the cases, which is the stage of the procedure, which the stage of the statutory process at which a relevant decision has been taken. And there are examples we give in that paragraph. The Everett case at first instance is a good example, I think, of reference.
So, sorry, which paragraph are we on?
So paragraph 23 of my skeleton argument.
Thank you.
So it's just for now to direct you to paragraph 70 of Everett, which was a case about an abatement notice which the authority wished to withdraw, and the key feature of the reasoning of Mr. Justice Richards at first instance, endorsed in the Court of Appeal, was that it was undesirable to leave this notice hanging, as it were, where the authority didn't wish it to be there, because there were enforcement provisions and potential criminal liability which would follow from breach of the notice. And if the authority wasn't going to enforce it, best that it was withdrawn. That it's the stage of the process is significant. And when one comes to the factors which the learned judge felt to be of particular significance in our case, paragraph 85 of the judgment, 85.1, the broad discretion to investigate, to discontinue, continue, and so forth, which I've just mentioned, which we say can equally apply once a report is withdrawn. Other broad discretions in the statutory scheme that she refers to. The other issue that perhaps falls under 85.1, which she'd earlier mentioned in her list of factors, was that of the informality of the Ombudsman's process. And you have some authority on that in Bundle 2, tab 25, the case of Miller and Health Service Commissioner, and paragraph 55 at 550. Now, not a case about functus, I would emphasise, but Lord Justice Ryder in that case emphasising it is important that the court does not import into the informal non-judicial process of administrative and complaints adjudicators like the Ombudsman the procedures of courts and tribunals. The adjudication process is an informal resolution of a complaint or problem where other remedies are not reasonably available or appropriate. Entirely within the gift of the Ombudsman, provided her decision-making process is lawful, rational and reasonable. And I say that is a significant point in weighing up what the claimant says has to happen in a case such as the present, which is that the administrative court has to get involved to set aside a decision.
But that's to confuse the procedures that the Ombudsman adopts with the procedures that the court adopts if somebody complains about a decision, isn't it? Well, I suppose it goes back to your point, because the Ombudsman can stand in the shoes of the court, short circuit the wrongs of the court.
Well, it's a general point which highlights the difference between the informal Ombudsman procedure on the one hand and the formal court procedures on the other, which I say is consistent with my submission that problems such as arose in the present case ought to be capable of being dealt with by the Ombudsman himself without the intervention of the court. Paragraph 85.2 of the judgment on 152 of the core bundle, the LGA does not, 74, does not expressly confer a more limited power of review. It's simply silent on the point. And the presence of express powers of review in cases like Dickens and San Bettine has been significant and indeed determinative of there being no implied power to review. But that's simply not this case. The legislation is simply silent, as the judge says. 85.3 is the legal rights point, that I think I've dealt with already. We say is significant. Ombudsman doesn't determine legal rights. And 85.4 is a point, and we say an important point, about the stage of the statutory process at which a report is issued. And if one considers the statutory process, section 31 alongside section 30, it's crystal clear that the Ombudsman is not functus in relation to a report once it's issued. He then, once it's issued, embarks upon a process of liaison with the local authority as to whether his recommendations are to be followed or not.
Well, the argument would be that he's functus as respects the function of producing the report. Never mind that he's got other things to do as a consequence of having produced the report.
Well, yes, I understand that's the argument, but it's not and there are cases where the classic case of functus is a court, for example, you make your decision and then it goes to appeal or not.
But that's because the Ombudsman isn't just performing one function under the statutory scheme, he has more than one, whereas the court just has a function of hearing the case and making a decision.
Well, the Ombudsman's, and one can call it different functions or the same function, the Ombudsman has powers and duties in relation to a report once it's been issued. So he's
not functus for all purposes.
Yes.
When we talk about being functus, we're talking about functus in relation to particular functions. And the function we're here concerned with is the determinations that he makes in the report.
Yeah, well, no, I'm sorry. I didn't mean anything particularly clever by that. I simply meant I'm simply making the point that the report is a particular stage in an ongoing process.
I understand that.
Which
but the logic of your argument is that equally be a power to revoke even after going through those stages.
Well, in theory, but the power. I mean, one can see that it would be much more difficult to justify exercising the power if one had got to the end of the process than if one was at the enforcement process than if one is at the start of it. But the point about the enforcement process.
Why? I mean, if there was a reasonable belief in the Ombudsman at that stage that the report was legally flawed, there would at least be a power to revoke, you say?
There would be a power, but whether it would be appropriate to exercise it, whether there was a compelling reason to exercise it, the somewhat different considerations may arise.
Is the compelling reason part of the formulation, which was before the judge?
Yes, that's what I submitted, and I submitted as I've submitted to you that the power is to revoke where reasonable belief in legal error, but only to be exercised in compelling circumstances, subject to the jurisdiction of the court. For example,
consider whether there were compelling circumstances in this case?
I'm sorry, Lord.
Did the judge consider whether that aspect was fulfilled? I'm not sure it forms any part of her formulation of your submission.
She didn't consider that. But for example, one can imagine there could be a report which contained legal errors which didn't really affect the results, or which were were not material to the outcome.
Or per your submissions a moment ago, because enough water had flowed under the bridge that it really wasn't appropriate to do it at this stage, neutrally.
Yeah. But
which might have been a consideration which arose in August 2019. But anyway, that's not addressed.
No. And I think my learner friend quite fairly has set his stall out on there's no power at all, and not that the power was inappropriately exercised if it existed. So the point about the ongoing process, though, is we say it gives, and Section 31, we say it gives a clue to whether the Section 30 power can be exercised on more than one occasion. The point being that if the Ombudsman becomes convinced that his report is materially flawed as a result of legal error, then it makes no sense for him to be forced to stick with the report report and go through the enforcement procedure to seek to ensure that the local authority gives effect to recommendations which shouldn't have been made. And we've explained in our skeleton argument, paragraph 24(3), what the consequences could be, and we say at the bottom of page 15 of the skeleton, it makes no sense whatsoever for the Section 31 enforcement procedure to be followed through in these circumstances. On the claimant's analysis, the Ombudsman must stand by a report he considers to be erroneous unless and until it's quashed. He must then A, take further action to enforce the terms of the erroneous report, B, take no action when the authority does not implement the report because he regards the report as erroneous, or C, publish a further report pursuant to Section 31(2)(a), in which it is explained that no further action is to be taken because the Ombudsman regards the report as erroneous. And what could have happened, I suppose, in this case, is instead of withdrawing the August 2019 report, the Ombudsman could have written to the parties to say, well, we now see that there are serious legal flaws in the August 2019 report. We're not going to take steps to enforce it. We shan't be insisting that the local authority take the steps that we've set out. Claimant ends up in the same position in substance. They're not getting their feedback or indeed any reconsideration of their fee. But one has the unsatisfactory circumstance of an erroneous report laying on the record.
Or not. It may not be an erroneous report. All it is a report which the Ombudsman believes is erroneous.
Well, that's not the facts of this case. We say it was.
You say it isn't.
But
Mr. Hunter says it is.
In any event, the test you're arguing for is not a test of whether or not the first report is in fact unlawful. Your test is whether the Ombudsman reasonably believes it's unlawful.
Yes, but in terms of if it's the questions mostly on the facts of this case, but Lord, the point remains that even if it's simply reasonable belief, on the footing of reasonable belief, the Ombudsman could write to the parties and say we now believe the report to contain serious flaws. We're not going to revoke it because we see there's some difficulties in that. Could have said, but we won't be taking steps to enforce it. But that's just not very satisfactory. and that highlights, we say, that there ought to be the power to set the record straight in the first place.
So it's my fault. I'm not really understanding. I thought your earlier submission was it would be unsatisfactory if the power didn't exist, because there would be an obligation to take the enforcement steps under Section 31.
Yes.
I've obviously misunderstood the submission you were making a moment ago, which is it would have been open to the Ombudsman, without revoking it, to say we're not going to take the enforcement steps, and that would have had the same result.
Yes, I can see that's slightly unclear. The Ombudsman has a duty to embark upon the enforcement process in Section 31. So the report is laid before the authority considers it, and then 31(2)(a), the Ombudsman has to make a decision on whether what the authority proposes to do is satisfactory or not. And if he didn't have a power to revoke, as I'm arguing for, he could say to the parties, well, when it comes to section 31(2)(a), we're not going to insist that, or to stand by the report and seek to require the authority to do anything. Now, I'm not saying that that's a desirable state of affairs. I'm saying that's undesirable, and that highlights that the enforcement process really only makes sense if in these unusual cases the record can be corrected before enforcement is embarked upon.
So you're saying that if the Ombudsman doesn't have the power for which you're contending, the Ombudsman must therefore have a power to ignore the provisions of section 31(2) A?
Well, no, it's not ignoring them. It's saying it's 31(2)(a)(b). The Ombudsman has to decide whether he's satisfied with the authority concerned with the action which the authority concerned have taken or proposed to take.
Yeah.
And he could say, and I'm not saying that this is undesirable, but he could say, we think we made a mistake in the report. We're satisfied that the authority is not taking any action on it.
I see. There might be a Padfield argument there, but anyway.
Well, maybe that's the alternative is that the Ombudsman has to proceed to enforce, to seek to give effect to the conclusions of a report which he believes were mistaken.
Yeah.
That is undesirable, we say, and that is a clue to the implication of power to review. And there are other powers. I think I've mentioned section 31(b) yesterday. Powers within the statutory scheme where it's plainly desirable for the Ombudsman to be able to revisit the exercise of a power. So section 31(b) is the issuing of a statement of reasons because the Ombudsman is satisfied with action which the authority has taken or proposes to take, and then the authority doesn't take it. And there are similar points to be made on section 24(a)(7), where the Ombudsman may decide not to investigate because he's satisfied with the action which the authority proposes to take. And section 31(2)(a), where the Ombudsman can decide not to make a further report because he's satisfied with the action which the authority proposed to take. If they then don't take it, surely he should be able to revisit that and continue with the process. No, I accept the point Model put to me yesterday, well, that's not exercising the same power twice, but it is revisiting and revoking an exercise of discretion under these different powers. Again, in an informal process, that is plainly desirable.
Well, what's the time? I mean, what's the time limit?
What's the time limit for complaining to the Ombudsman?
No, I mean, well, anyway, don't worry.
Well, I can see that. Well, what if somebody comes 5 years later and says, "Oh, you were told the authority was going to do this and they didn't do it." That might be my lady's point. I'd expect we would hear about it much sooner than that.
But more generally, the power for which you're contending is not time limited as such at all. The only temporal limit on the revocation, which your formulation allows to be taken into account, is the compelling reasons qualification.
Yes. And there's the even if there wasn't a compelling reasons qualification, there's simply the normal principles of public law. There may come a point in some cases where it's just not lawful as a matter of public law to seek to wind the clock back.
No, but if, for example, it were a decision in favour of the council, which had said some unkind things about the applicant, and 5 years later, the applicant, and it's been published, as it may normally be, and 5 years later, the applicant says, well, I think you were jolly unfair on me because this has just come to light. There's a power to revoke.
Yes, I mean the Ombudsman's, as I said yesterday, and as you've seen from the judgment below, has a policy, pardon me, about factual representations following the issue of a report, which does have a timescale attached to it. It's one month of the decision, page 148 of the supplementary bundle.
Yes, but you're arguing for an implied power, and there's no time limit on the implied power for which you're arguing.
Well, I mean, there's no time limit on the implied power to review for fundamental mistake of fact. We have, as a matter of good administrative practice, imposed one. And the same may in practice apply to the power which I seek today. But
have we got the guidance? Have we got the guidance in the bundles?
yes, sorry, 148 of the
Divided 37. Yeah.
Thank you.
Supplementary bundle. Which does start off by saying our decisions are final and there's no appeal.
yes,
Although it does go on.
yes, and we obviously don't want to mislead parties into thinking that.
But your submissions would mean that first sentence is not accurate.
Well, the rest of the policy shows it's not accurate, if one wants to be strict about it. I mean, that's the general principle, and then there are limited exceptions.
And your policy doesn't talk about reasonable beliefs in errors of law.
No, it doesn't really. As I said, this is an unusual case. Not one that routinely arises and which has been subject to a policy. Well, I think I'd better move on the judge's reasoning, which we respectfully support. To the Dyer case. I'm not going to say very much about it. I endorse what the judge accepted my submissions about it in paragraph 93 of the judgment. It's not binding on you. I would say that it's a relatively, whilst any judgment of Lord Justice Simon Brown is with great respect, it's a relatively flimsy basis for the assumption that certainly some of the academic authors have made on the basis of it, that no ombudsman can be entitled to withdraw a report once issued. It's a relatively flimsy basis for that, because it was effectively a one-sided argument, a litigant in person against the First Treasury Council. There was only one possible answer, really, to the issue as it arose in that case. As you'll recall, the issue was there was a complaint that the Ombudsman had not investigated all of the complainant's grievances, and the court rejected that criticism on the basis of the broad discretion of the Ombudsman to decide what to investigate. And it really followed inevitably from that when the argument arose that the Ombudsman was required to reopen his investigation to investigate the things that he legitimately decided not to investigate first time around. There was really only going to be one answer to that question. There was only very brief consideration given to the functus issue, and the reasoning of the court on page, so it's bundle 1, tab 3, page 55. The reasoning of the court at letters F to G is simply on the basis of the express powers of the Parliamentary Ombudsman not extending to a power to reopen. Whereas, no doubt, had there been fuller argument in a better case, the court would have considered what's usually considered where this issue arises, which is the implication of powers. Section 12, perhaps, examining the statutory scheme as a whole, and so forth. But this was a relatively quick decision on an argument to which there was only going to be one answer.
Well, the judgment was reserved.
I'm sorry, quick, not in the sense of the point of time at which it was issued, but the reasoning.
Quick by the present day standards of the Supreme Court, anyway.
Yes, sorry, I should have said brief rather than quick. There is, though, I think as the judge highlighted in paragraph 93 Roman 2, an important distinction between the statutory scheme which applies to the Parliamentary Ombudsman on completion of a report, section 10 of the Act, which I'll just give you the page number, it's bundle 3, tab J, page 892. On completion of a report, it's provided to the MP in Parliament who made the initial complaint. And there's no process of enforcement, as there is in section 31 of the 1974 Act. And that, if one wants to go further down the Eastleigh-Bradley rabbit hole, that was an important point of distinction between the Parliamentary Ombudsman and why the Secretary of State was entitled to dispute the findings of the Ombudsman in Bradley, where the local council had not been entitled to dispute the findings of the Ombudsman in Eastleigh.
But never mind the enforcement provisions. In each statutory scheme, the relevant ombudsman has a has a function of producing a report, and that's the relevant function.
That's right, my lady. But as you know, I rely on the enforcement provisions of Section 31 as an important clue to the breadth of Section 30, and onwards if he doesn't have that point. There's also a parliamentary privilege point as to whether it would be trespassing on the privileges of Parliament to withdraw a report which had been provided to Parliament. So I'm not asking you to say that Dyer is wrongly decided, but simply that it's made under a different statutory scheme, and as in Bradley, you may focus on the scheme which you are concerned with. And the same point goes, and I think this is my final submission now, the same point goes for the other ombudsman cases which my learned friend has referred you to. He says that my submissions would put the local government ombudsman out of step with the other ombudsman. He referred you to Haywood number 2, bundle 1, tab 8, on the pensions ombudsman, which isn't a case about punctus, is a case about res judicata. But what one does see from Haywood number 2 at page 202 is the relevant provision on completion of an investigation in section 151 of the Pensions Act 1990, Pension Schemes Act 1993 as amended. And you'll see at the bottom of the page that the Ombudsman has a power of direction in subsection 2, and in subsection 3, the Ombudsman's determination is final and binding on the parties, with an appeal lying to the High Court. And subsection 5, any determination which he makes, which may be for financial compensation, for example, shall be enforceable as if it were a judgment or order of that court. Now, one could well understand in that context, where the Ombudsman really is exercising a quasi-judicial function, one can well understand that the principles would be much stricter when it comes to revoking, reviewing a determination. But that stands in stark contrast to our statutory scheme. The other case my learned friend referred you to was Walker, the Northern Ireland case on the Financial Services Ombudsman. And unfortunately, which is tab 4 of the authority bundle, which unfortunately you don't get the legislation in the judgment, but the Financial Services Ombudsman under the Financial Services Markets Act 2000, as the Pensions Ombudsman, has a power to make awards which are enforceable in the courts. I've got the relevant provision if you'd like to see it, but it's
just give us the section number.
Section 229 of the Financial Services and Markets Act 2000. Again, we say a very different
Thank
jurisdiction. So that only leaves the council's claim, which I think I've dealt with. We've dealt with in the course of submissions. If I'm wrong about the Ombudsman being entitled to withdraw the August 2019 report, then my submission is that the court should quash it pursuant to the council's claim. The council asks that you do that in your judgment, rather than remitting to the administrative court or anything like that, and we agree. And in those circumstances, the February 2021 report stands, and the appeal should be dismissed.
Thank you very much.
My lord, my lady, I'll deal with the grounds in the original order. So, dealing first with the question of withdrawal, which of course been here about this morning. The position that is put forward on behalf of the Ombudsman, as I understand it, is that the Ombudsman has a unique implied power. It said it's a modest extension of the law to provide power to withdraw where reasonably considers a material error, or there are, if I say it properly, material error law, and there are compelling reasons, but doesn't contend that that applies to anybody else, including any other ombudsman. My lord, that's an extraordinary submission that principle should apply solely to one statutory ombudsman, and it's not correct, and there is no juridical basis for it. Firstly, dealing with section 12, my learned friend was asked to explain where in the wording of section 12 of the 1978 Act one can see the implication of a power of revocation, and he said it's implicit. So it's implicit in a provision which itself is saying what is implicit, which is, in my submission, quite a difficult argument to run. In any event, doesn't deal with some of the key points that I made yesterday, including that section 12 isn't some kind of magic or alchemy. It can't turn a duty such as that which exists in section 30 into a power. All it does, where it has application, is to imply continuity of the power over time. That is, in my respectful submission, put beyond doubt by consideration of the provisions which, very helpfully, my lady has asked us to address in section 14 of the 1978 Act and section 32, because one can see that the draftsman in both cases, and Parliament therefore, had before it provisions very close in the same section in the 1889 Act, which is essentially mirrored but divided into two different sections in the 1978 Act. Very similar provisions, but in the case of rules, regulations and bylaws, whereas provision was made for rescinding 1889 wording or revoking 1978 wording, the same thing was not done in relation to powers and duty. And by the principle articulated in paragraph 75 of Colonga by my lady, the close juxtaposition in similar provisions, where provision is made in one case for revocation and not in the case of the other, is a powerful indication that it isn't implicit, if it ever could be, in my submission. That leaves, if that's right, and section 12 can't be used to derive a power of withdrawal or revocation of a report. One is driven to ordinary principles of interpretation, and my learned friend said it doesn't very much matter whether one relies on section 12 or ordinary interpretation, but in my respectful submission, it does matter. Because if one is looking, if section 12 doesn't suffice, one has to find a source within the statute for the implied power. And notably, both in the court below and in this court, neither my learned friend nor the council for the local authority, was able to identify the particular source of that power. And as my lord Lord Justice Popplewell pointed out this morning, the wording of Section 30 itself seems particularly inapt for that, because if you are reopening an investigation, your investigation is not complete. So there's not only there is no source, and it's, as I say, it's telling that the respondents in this case have never been able to identify the source of the implied power within Part 3 if they cannot rely on Section 12. And neither did the judge, because the judge pinned her colours to the mast of Section 12. So the court will not find within the judgment any identification of where that implication could arise. The judge dealt with the case on the basis that Section 12 was sufficient. And so, in my submission, if the court accepts the appellant's submissions in relation to Section 12, the whole edifice of the respondent's case and the judge's finding below comes crashing down. My Lord, and there is, to the extent that authority for what I've said is needed or available in the authorities we have, in relation to the needing to find a source for the implication of a power, the court finds it in Johnson, tab 11. I think that's the first bundle of authorities. Page 263. I appreciate this is not, it is stated more authoritatively elsewhere, but there is a reference. So page 262 going over to 263. So the argument about power to refix 262 over to 263, the submission that was made, it is unnecessary positively to apply continuity of power capable of being exercised as arising from the language and structure of Section 256 of the 2003 Act, because the claimant in that case was relying on Section 12. So conversely, if Section 12 has no application, it is. These are the submissions of counsel, I accept, but these, it was obviously correct and not disputed by the others, the claimant in that case, that that in the case where Section 12 has no application, it is necessary to find where the structure or language of the statute justifies that implication.
Sorry, which bit are you reading from?
I'm reading from Roman numeral 1, letter A, the top of page 263. It is unnecessary positively to imply continuity of power. And we see that's because the parole board was relying on Section 12.
Right, so that's the parole board's argument. Did the judge accept it?
Well, the judge accepted that Section 12 prima facie applied, and therefore he looked for a contrary intention. So yes, he did accept that, but then found the contrary intention. Well, I was trying to find if there was anywhere else in the authorities. Clearly, there are other authorities which state the principle better, but it is, in my submission, correct that where Section 12 can't be relied on, you have to positively imply it on the wording structure. My learned friend also referred to the modern approach to judicial review, in particular the pre-action protocol, which encourages parties to try and resolve matters without taking them to court. It has always been acknowledged within that pre-action protocol, first of all, that there are cases that aren't suitable for resolution in that way. Cases, amongst other things, where the defendant is functus and has no power to revoke the report. In any event, clearly, the contents of the pre-action protocol cannot influence the interpretation and construction of the 1974 Act, written 30 years before it, and obviously having quite a different status from the pre-action protocol itself. And insofar as it said that's the modern approach, well, it's a modern approach that is not universal on any view, because there are numerous public authorities, of which we have many examples in the cases put before the court, which are funders, at least in relation to certain functions at certain points. And so this modern approach is a very patchy approach that can only apply in relation to specific cases at specific times. No help is given in my submission from reference to the pre-action protocol or so-called modern approach. My Lord Justice Popplewell asked both counsel, I think, to address the juridical basis for the fraud exception. Well, insofar as I've been able to do that, as far as the basis for the fraud exception in relation to judgments, the leading authorities, as far as I'm aware, is TACAR in the Supreme Court 2019 UKSC 13. So TAKHAR UKSC 13 2019 and paragraph 43 of the speech called Kerr. There is reference to earlier authorities and the principle that thought, in particular, HIH casualty in general insurance and Chase Manhattan Bank in 2003, fraud, and the speech called Bingham. Fraud is a thing apart. It reflects an old legal rule that fraud unravels all. Once fraud is proved, it vitiates judgments, contracts, and all transactions whatsoever. So in my submission, it is a common law. As far as the court's concerned, it's a common law principle. But of course, it only vitiates, as was pointed out this morning, if it has actually occurred, which has to be determined in the case of the courts by the courts. So in the case of the courts, it is an exception to the principle of finality, in the sense that a court of coordinate, either the same court or a court of coordinate jurisdiction, may, if the exception applies, set aside its own judgment on that basis. It does not follow that the same is true of all administrative bodies, because plainly the correct body to determine whether there has been the fraud is the court. Whether that is the case in relation to the Ombudsman, for example, if there was a fraud that led to a particular outcome in a report, it would always be open to whichever party that was aggrieved, or the Ombudsman himself, and I'll come back to the procedure if the Ombudsman did want to challenge his own decisions, to apply to the court by way of judicial review to set that aside, and the court could decide whether the fraud amounted to good enough reason. But my Lord, as I prefer to remain neutral on whether the Ombudsman himself can set aside his own decisions for fraud, or whether it was a matter the court should determine. Because in my submission, even if the principle does apply, it is a clear exception within the common law, and therefore it is not one that can be extended more widely to include, in particular, errors of law or reasonable belief in errors of law. And I know my learned friend doesn't say that such a principle, as I say, the principle he argues for is confined uniquely to this Ombudsman. So it isn't a general principle such as the fraud exception that he argues for anyway.
Sorry, that's not my submission. I'm making a submission in this case on this statutory scheme. I don't exclude that it could apply to other Ombudsmen. I'm just not inviting this court to say that.
Well, my Lord, it's perfectly clear that it doesn't apply to in the case of those Ombudsmen that have been alluded to already, the Financial Services Ombudsman, or the Pensions Ombudsman, or indeed the Parliamentary Commissioner. So all the Ombudsmen that have been, the courts of schemes have been considered by the courts before. It's clear in the case of the Financial Services Ombudsman and in the case of the Pensions Ombudsman, because there is a statutory right of appeal to the High Court. So it's plain that the Ombudsman himself can't set aside his own decisions for legal error. That's a matter for the court on appeal.
But that's why Mr. Coppell isn't making submissions about the other ombudsmen, because the statutory schemes are significantly different, he would argue.
And we haven't looked at the schemes of
And,
all,
and
of all
this case
ombudsmen.
isn't about the other ombudsman, so I mean, this point I don't think
No,
really gets you anywhere.
no, but I don't know,
I mean, Mr. Coppell is not saying this is unique and all other ombudsmen are in a different position.
well then it
He's
has
saying this is this scheme, and I'm saying that is what the position is for this scheme.
Yes,
And
but he's arguing
we haven't looked at all the schemes for all ombudsmen.
no, but
Even you haven't sought to draw our attention to the terms of the
No,
schemes,
because-
let alone any decisions on the schemes.
No, my lord, because quite I accept the position that there are material differences in the statutes, and so it wouldn't be.
The statutes that you've referred us to in relation to two particular ombudsman schemes,
Yes.
which is not the whole set.
No, but they're the ones that are being considered by the courts in relation to the question of the finality of judgment and res judicata, which is why those authorities have been selected. But I appreciate there are material differences, and that's why there is limited amount to be gained by reference to. My point is a slightly different one, my lord. My point is, my learned friend he said it is a modest extension of principle. What principle? What I understood that to mean, the principle that decisions can be set aside for fraud or mistake of fact. What I'm submitting is that it's either a unique exception, but if my learned friend isn't saying it's a unique exception, he's just not saying to which other tribunals or bodies it would apply. It is not a modest extension. It's a very significant extension of any established exception in the case of fraud. You can't have it both ways. If he's not saying it's going to apply to this ombudsman, then it might have potentially very significant ramifications, given that most administrative bodies are controlled by judicial review. And that would seek to, if it's a general principle, usurp the court's function more generally. Well, the court yesterday referred to the case of Milburn, and my learned friend addressed that in his submissions. I respectfully agree with him that Milburn is of limited assistance. First of all, because it was a case concerning the section 26(6)(a), i.e., where there is a right of appeal, reference, or review to a tribunal. Not whereas that is the question here, and there are material differences between the wording of 26(6)(a) and 26(6)(c), which refers to a remedy before a court. My learned friend sought to rely on it, I think, solely for the principle that when construing sections 26 as a whole, and hence 26(c), one should give it the fullest reasonable meaning in order to achieve what the objective that Lord Denning, I think, referred to in the Bradford case of ensuring that the Ombudsman doesn't trespass on the jurisdiction of the courts. I don't disagree with any of that, but I point out that even in that case in Milburn, as the court can see, if one turns to paragraph 67. I'm not sure. If I just add in parentheses, I'm not sure it matters in this case because it isn't in dispute in theory that the ambit of judicial review is wide and therefore can embrace an awful lot. But it was only paragraph 67. We see that in the last 4 lines that the central finding was one in relation to Mr. Milburn's views. They were viewed as an integral part of the Special Educational Needs Tribunal's determination, and therefore they were, even though they weren't directly the matter which was appealed, because they formed the essential basis of the appeal, they were caught by 26(6)(a). But that, as I say, that doesn't take the matter further in this case, because first of all, it's not a tribunal case. It's not a case where the claimant did resort to a legal remedy in respect of the matters in the complaint. And for reasons I'll come to, the matters which the Ombudsman declined to consider whether it was under 26.6c or 24.6, namely the contextual question of, or the contextual issues relating to the judicial review, were not matters which either required a court's determination or were suitable for a court's determination. It was simply, as was put to my learned friend yesterday, a matter of the Ombudsman taking note of the fact that the court had found the decision or decisions to be tainted by apparent bias. In relation to, my learned friend referred to a number of authorities in support of the argument that I'm thinking particularly of Persimmon, in relation to the argument based on ordinary interpretation, not section 12. It said, well, in Persimmon, the court didn't find it difficult to imply a power to revoke a local plan without reliance on section 12. But one can see from the head note, which is tab 12, authorities 1, page 274. The summary of what was held, next to letter F, just above letter F, that since such a power, i.e. to withdraw a local plan prior to adoption, was necessary in order to avoid a local harm having to put through the costly statutory procedure, including a public inquiry, when the local planning authority knew in advance that it wouldn't be adopted, and in light of the statutory predecessors and Regulation 25 of the 99 regulations, the Act was ambiguous and was to be construed as impliedly conferring on the local planning authority power to withdraw or abandon a local plan. So I'd make 2 points about this. This is an implied power to revoke a provisional decision that has not become final. The whole point is the plan has not been adopted. If the plan has been adopted, Flaxby, the following authority in the bundle, paragraph 223 explains the position. You can only revoke an adopted local plan through application to the court. That's the only way of stopping that. So number one, it was provisional, but number two, it was also necessary to avoid an obvious absurdity, namely everybody, not just the local planning authority, all the developers, all the local interested people, sitting in a public inquiry potentially for weeks or months on a plan that everyone knew was never going to be adopted at the end. So it was a process of necessary implication from the history, structure, the ambiguity of the provisions and the mischief that would be caused. Similarly, in the case of Everett and abatement notices, the key consideration was that there were penal notices of potential penal effect, and an authority shouldn't be required to maintain. It was obvious, looking at the structure of the Act, that the authority wasn't required to maintain them if they no longer felt that the conditions for their issue were satisfied. Again, very, very different from this case. One can readily see why such an implication would arise. In that case, it is in no way analogous to the circumstances of this case. Legal rights. My learned friend's submission with respect at times elided the question of whether a decision determines legal rights and whether it affects legal rights. I would accept plainly the presumption that a decision is final and incapable of revocation is at its strongest where there is a determination of legal rights. But it also applied the wording used in the extract from Wade and Forsyth cited in Johnson was affecting legal rights, and that was also the touchstone of Lord Justice Simon Brown in Dyer when considering what the requirements of procedural fairness were in that case. And it is plain, it was as it was conceded and held by Lord Justice Simon Brown in Dyer, that the parliamentary commissioner's decisions do affect legal rights. The same is true of at least some of the local government ombudsman's decisions. The Ombudsman does not determine legal rights, I fully accept that, but his decisions can affect legal rights. And it matters not whether that is the case on the facts of this particular case, because the rule as regards functus must be the same for all cases. It can't be that the Ombudsman is functus, having issued a report in a case that affects legal rights, but not one where it doesn't affect legal rights. It's sufficient, therefore, that some of his decisions may affect legal rights. And I don't think it can be controversial that is the case, but if it is, to give an example, which I think would be a very familiar sort of scenario that would arise, or does arise in Ombudsman's complaints, a neighbour complains about a planning authority having allowed a development to go ahead next door. The adverse impact it has on their occupation of the home. Article 8 rights are therefore engaged. It is established or even admitted that the authority has mishandled the situation, and recommendations, finding maladministration is made, and the Ombudsman recommends that things are done to put the situation right. That is a decision of the Ombudsman which affects the party's legal rights, as far as Article 8 at least is concerned, if one embraces those rights within that. And it may also affect other legal rights. For example, if there is a dispute about, there might be a dispute about the payment of fees under the Town and Country Planning Fees regulations. The Ombudsman may consider that it's not suitable or reasonable to expect a householder, for example, to judicially review the council over it, so accepts the complaint. The Ombudsman recommends that the authority does something in relation to fees. Again, affects legal rights. May not determine them, but affects them. May I say something about finalities? What my learned friend submitted, that if the court were to allow the appeal on ground one and find that the Ombudsman had no power, it would mean it would not serve the interests of finality, because matters would simply proceed by way of judicial review instead of the Ombudsman having the convenient mechanism of being able to withdraw his own decisions. That is not the meaning of finality in this context. When finality is discussed in the context of functus officio and related doctrines such as res judicata, what it means is that the decision of the court, tribunal, or other body is incapable of being revoked by the court itself or a tribunal of coordinate jurisdiction. It's subject to judicial review or appeal. So that's always the case with final decisions, save those of the Supreme Court. In relation to procedure, and the desirability of the Ombudsman having this power, the Ombudsman, I think, accepts, as it must do, that in cases where there is a willing claimant, as there was in this case, where the matter would be brought forward, all the Ombudsman has to do is consent to judgment. So if the Ombudsman had taken that course in this case, it is possible or even likely that there would have been a judicial review, but the Ombudsman would not have had to take part in that. He could have left it to be fought out between Tewkesbury and my clients. And that would, I'd have thought, be the normal position. The Ombudsman would indicate that he, unless the court required his assistance, the Ombudsman would say that they consent to judgment. It would be a matter for the interest party if they wish to defend it. in many cases, perhaps they wouldn't. In some cases, perhaps they would, but they would at least have the right to do that. If the Ombudsman says, well, what about the other cases where the Ombudsman, of his own motion, implausible though it may seem, discovers a legal error in one of his decisions, and the party against whom the decision was made isn't willing to bring it before the court, what is he to do then? Well, first of all, if it matters, you shouldn't trouble the court with something that is not that is trivial or not of significance to him. If it matters enough, then there is no reason why the Ombudsman, if the other party is not interested in bringing the claim, could not support a claim for judicial review. For example, planning authorities occasionally bring claims for judicial review against their own decisions, and they do it by nominating a person within the council with an appropriate standing. So, for example, the chair of the planning committee, the chief executive officer, perhaps a legal officer. There's no reason why the same mechanism shouldn't be open to the Ombudsman if they are concerned enough about a decision to want to have it quashed of their own motion, which I would imagine is a wholly exceptional course if it ever arises. And if I could just add that this possibility was alluded to in Sambertine by Lord Justice Peter Jackson, where he, at page 220, letter G, where he says that if Waltham Forest were sufficiently concerned with the decision, it could have brought judicial review proceedings, and unlike, still less likely, but not impossible, Brent itself could have brought, could bring a judicial review. Well, if I could turn next to the additional grounds, so the question whether or not, even if there was power to withdraw the August report, it should be quashed. My Lord Justice Popplewell asked my learned friend whether, if my client's submissions, my submissions on behalf of my client on retrospectivity are correct, the 2019 report would fall to be quashed in any event because it dealt with the matter on the wrong basis, namely that the council hadn't exercised its discretion when in fact it had, perhaps in a faulty manner. And I think my learned friend agreed with that suggestion. My Lord, I would respectfully disagree on this basis. It is the appellant agrees, indeed, the appellant positively asserted that the basis on which that decision was made wasn't factually the correct one, because as the court has seen, the correspondence at the time appears to clearly show that show at least fairly convincingly show that the council did. What the council did wasn't say we are not going to consider exercising discretion at all. It exercised it, but adversely to the appellant. But that is an error of fact rather than an error of law. It was for the Ombudsman to decide on what basis or how the council had responded to our complaint. So although we disagreed with that factual finding of the Ombudsman was, as a matter of law, entitled to make it, because, not least because, as I say, the council itself had, that was the council's own case. It said we admitted we did not exercise discretion. And I wanted to draw the court's attention, if I may, to the particular part, the particular admission which was relied on, and it's cited in the judgment at page 142 in the core bundle. So paragraph 45, page 142. whilst the Ombudsman's right to say the Council didn't consider exercising its discretion to refund the fee after the application submitted, it did consider waiving them before the application was submitted and exercised that discretion against the complainants. So although we think that admission was wrong, and it's shown...
Well, it's an assertion.
But
It's got to be one or the other, isn't it? They've either have got... I mean, they did make a decision saying we're not going to refund the fee.
yes.
That can only have been on the basis we have no power to do so, or if we do have power to do so,
We don't exercise it.
we're deciding that we shouldn't.
Yes.
So
No, I do. Well, I know, and on the horns of that
you
binary...
can't hold them to a quote admission by saying the admission's wrong, but they must be bound by it.
Well, I'm not holding them to the admission. I'm saying that the Ombudsman was entitled to proceed on the basis of that admission at the time that he made the decision in the August report. That is...
But equally, you say, on the other hand, he wasn't entitled to proceed on the alternative, i.e. that the assertion was right, that they were declined to refund because they had no power.
No, sorry, my lord. I accept that the position is either they did not consider exercising a discretion, or they did and exercised it adversely. I don't even, but if there was no finding in the 2019 report, and if there had been, it would have been correct, that they did so. I mean, the Ombudsman even here is not suggesting that the Council relied on the no power defence that they asserted during the course of the complaint and in these proceedings at the time of the matters complained of. It was simply a question of whether or not, I appreciate maybe the court may find it difficult to see how the Council could do it on any other basis, but there are only two interpretations of the letters that are possible. Either exercise discretion adversely, or it had completely shut its eyes to the exercise of discretion, so that one could say it didn't consider exercising it at all. And my submission, in the context of the additional grounds, is the Ombudsman, that admission entitled the Ombudsman to reach the conclusion he did as a matter of law. If the court's against me on that, however, then and feels that the choice is stark and binary, well then that tends to show that the February 21 report must fall. So if the court, if the premise of that question is accepted, and it's then for the reasons I'll come to in relation to ground 2, the 21 report must fall, because the Ombudsman, my Lord Justice Dingemans asked my learned friend, where has the Council addressed the central point that, or the central point in the complaint, that the Council was at fault in not taking on board, or not properly taking on board, the findings of His Honour Judge Jarman when considering whether to retain the fee when it was asked to refund it. And it wasn't, and as I think my learned friend candidly admitted, it has never, the Ombudsman never did that, not in any of the draft decisions. And if I turn now to ground 2A, that was because in every iteration, in every draft decision, and in both of the final decisions, the Ombudsman said we can't consider the judicial review. We cannot consider the complaint in the context of the judicial review, because it will necessarily require us to decide whether the first two refusals of planning permission were null and void. So they consistently, my Lord, and I could give the references rather than taking your Lordship time, given the amount of time available. Draft decision 1, page 4.
It doesn't matter what's said in the draft decision. It's what's in the February report.
It is, but if the court wishes to, one could see it traced through the draft decision. So there's two things that were consistent. One, the Ombudsman consistently said we can't look at what His Honour Judge Jarman found in the judicial review, because we'd have to then decide whether the two refusals of planning permission were null and void. And equally consistently, my client and those acting on behalf of my client said, no, you don't. You just need to look at whether or not what is Honourable Judge Darman found, and whether this was a factor which means that the council was at fault in how it responded to our request for the return of the fee. And that is a question of, so it ultimately boils down to a question of law, whether the reasons given by the Ombudsman for not looking at this aspect of the context, what is Honourable Judge Darman found, were valid reasons involved. And as I submitted yesterday, they were not. It was completely unnecessary for the Ombudsman to decide whether the decisions were null and void. All he had to look at, I think my Lord said, is whether the fact that the decisions were held to be, the second refusal was held to be tainted by apparent bias, was something which should have factored into the authorities, the authorities' decision in a different way. And he refused point blank to do that throughout. He never looked at it. If he was wrong that he couldn't look at it without making decisions on the validity of the two refusals, then ground 2A context in my submission must succeed. Well, look, can I just deal then with the point put by my learned friend, which in fact was the focus and the submission, part of his argument he spent most time on yesterday, which is the submission that a short answer to ground 2 is the findings of the Ombudsman in paragraph 42A. Well, that is page 422 going over to 423 of the bundle.
Yeah.
My Lord, I appreciate. I think it's 1 o'clock, my Lord. I have about 5 minutes or so further submissions. If I.
Well, you need to keep going.
I will. Yeah, I will. My Lord, can I? Someone listening to my learned friend's submissions yesterday might not have been at fault for getting the impression that in February the Ombudsman had decided to reject the complaint entirely, to not consider it at all under section 26(6). But that's not what the Ombudsman did. He actually did. He completed investigation, and he issued or recompleted his investigation, and he issued a report finding no fault. Paragraph 44. Paragraph 45, decision. We have completed our investigation with a finding of no fault for the reasons explained in this report. Section 26, or whether it was 26(6) or 24(6) for the purpose of my submissions, doesn't matter. All he excluded was the things he'd hitherto consistently excluded, namely the Section 70A decision, what he sets out at 46 and 47 and 48. So he doesn't consider the Section 70A decision. He doesn't, and he doesn't consider the previous 2 planning applications, and he doesn't consider the judicial review. But he does consider the complaint that the council was at fault in not returning the fee. It's just that it's divorced from all context. And when he's considering that bare complaint that the council didn't return the fee, he considers it through the prism of the council's retrospective defence. We didn't have any power to do so. And he finds that the council isn't at fault because there are reasonable arguments both ways. All 42A says is we can't determine that question anyway. Whether that be under section 24A6 or 26(6. It is not a separate reason in relation to the fault ground. And well, could I just point out as well, the judge below only relied on 42A as an additional and sufficient reason for dismissing the fault, the fault argument. She did not treat it as a separate and sufficient reason for dismissing the context ground. and one can see that page 158, paragraph 113 to 114 in the judgment. Well, I'm conscious of time, so I will put it like this. In my submission, it's clear. If we are right on retrospectivity, then ground 2 succeeds on both the context and fault limbs, because the Ombudsman shouldn't have looked at it through the prism of the Council's retrospective defence, should have looked at the context of what happened. But my Lord asked me yesterday, my Lord Popplewell asked me yesterday whether there was a connection between the two, insofar as if the retrospectivity argument failed, it took with it, in effect, the fault limb of it. And I think I've had cause to reconsider it, and to the extent that I made any concession on that, I think I'm going to have to retract it, my Lord. I say even if, for some reason, the court were to find that it was relevant for the Ombudsman to consider the question of whether or not there was a power and whether it was reasonable to assert that there was no power, that still did not excuse his error in failing to consider the context as well. And so what I'm implicitly rejecting there is the submission made by my learned friend that if an exercise of discretion, a decision to exercise a discretion in a manner which amounts to maladministration, which turns out to be based on I'm expressing myself badly. If an authority purports to exercise a discretion it doesn't have, and does so in a manner which displays fault or maladministration, it can't actually amount to maladministration or fault if there was no power to do it. And that simply can't be right. That's to align maladministration or fault with injustice. And I give a simple example. If instead of the reasons it gave for not exercising discretion in my client's favour in this case, the council had said, we are not going to refund the planning application fee simply because you have red hair, to take the classic example, and then written offensive letters to my client, that would plainly be a case where there was maladministration. But if the Ombudsman had gone on to find there was no power, he might have found there was no injustice in the sense of financial loss, although it may well have found injustice in another sense. But that is how the concepts are different. Treating whether or not, going back to Liverpool and Bradford, maladministration is not about the merits of the decision or the legality of the decision. Maladministration is about the manner of the decision. And so if the contextual factors on which we relied were sufficient to found a finding of fault or maladministration, then the fact that there was no, that there might have been no discretion would have mattered. In any event, my Lord, my final point on this, of course, the Ombudsman declined to say whether there was a power or not. 42A. This is not a matter for me. So that wasn't the basis on which he made his decision.
So might that not be an argument saying that the Ombudsman shouldn't have embarked on the, or shouldn't have persevered with the investigation, because it boils down to a pure question of law. Does the local authority have the power to do it or not?
Well, but it doesn't boil down to that. As I said, what my client was aggrieved by wasn't just that they hadn't got their money back. What my client was aggrieved by was that they had not had their applications properly dealt with. They'd had to go to court to establish that they'd not had their applications dealt with. And can I just add on this, my Lord? I won't take your Lordship to it now, but could I ask your Lordship to read the facts of the case? Because it wasn't simply that the applications were determined by somebody who was married to a rival developer's planning manager. What happened were going to be recommended for refusal by the prior planning officer When Miss Desmond became involved, they reversed the recommendation, and then the council refused to acknowledge that they'd actually previously had a draft report ready recommending approval. So it wasn't simply her relationship with Mr. Shaw, the manager of Blue. There were a number of factors which my client felt at least reasonably aggrieved by. And
that's referred to in the Ombudsman's decisions.
I'm sorry, my lady.
No, I don't think any of that's referred to in the Ombudsman's report.
No, because the Ombudsman said we're not looking at the findings of the judicial review. If the Ombudsman had looked at them, the Ombudsman would have been able to say, well, it looks like things went pretty wrong here, and the appellant has been able, the complainant has been able to establish that they did go wrong in the court, and it's reasonable in those circumstances to ask the authority to reconsider its prior stance, having regard to what the court has found about it. That's the extent of the case. Well, there were just a couple of loose ends I wanted to pick up before going. The first one, my lady asked whether the letter at page 18, the first stage 1 complaint at page 18 of the supplementary bundle was a full document. It was the full document. It wasn't signed off. Another question that was asked was whether we could obtain a copy of the further article from judicial review. Unfortunately, there have been problems with a subscription to it, but it's not working at the moment. So I will try and obtain a copy. If I obtain one, if the court wishes to have it and my learned friend doesn't object, I will send it. I don't think it's going to help. The title relates to injustice, so I think it looks at Balchin from the point of view of injustice rather than Functus. But if the court wishes to be censored, I will send it as soon as I'm able. And then the final point then, the authorities, an apology. The authorities, well, my learned friend very graciously took it on himself, but I think I have to show them the blame for the order of the authorities, so I apologise if that's inconvenience to the court. My learned friend's fault.
Right, thank you.
Can I just, there was just one point. I did ask a point about the skeleton argument. And
Yes, my lady, sorry.
Application for permission to appeal.
Yes, the answer to that is yes. It was paragraph 83. In it, the text is the same. It was part of the skeleton argument that was lifted and put into the present.
Thank you very much.
All right, thank you. I think in terms of further materials, the only one I've got in mind that's been promised that we like are the two authorities referred to in paragraph 3 of Sambertin. But if I've missed some, you'll tell me.
My lady also inquired as to whether there had been subsequent cases, cases subsequent to Porteous
on fraud and mistake.
Other than Sambertin. There are. I've had the opportunity to look briefly. So I can send a list of, I think, 4 or 5 cases, or I can send the cases.
Well, was the question? There are numerous cases citing Porteous, but was the question whether there had been any cases where a decision had been set aside on fraud or mistake of fact?
Yes, I think
yes.
What we're interested in.
Yeah.
Not Porteous in general.
Yes.
But cases set aside on fundamental mistake of fact or fraud.
I think I would need to investigate that. I'm not aware of. I did look at that question. I couldn't see any original.
Right. Well, you can do your researches. You can liaise and let us have by close of business Monday. Not just a list, but any of the authorities, copies of the authorities you find, please. The one other matter that's outstanding is that I canvassed in the course of submissions what the position would be were we to conclude that there's no power to revoke, but that the August report is flawed. The common position seemed to be then we simply decide whether the February 2021 report is flawed or not, without there being a separate, an ancillary question as to whether in some way we're precluded from doing that because we would be quashing the August report, but we would only be quashing it now, and therefore the February 2021 report was produced at a time when there was still in existence a prior report. I suggested that if you were going to say that that was a point that we needed to address, it was for you to do so and to show us that it was within your grounds of appeal. You haven't. Can we take it, therefore, that that's not a point that you're taking?
I don't think I can.
Thank you for that clarification. All right, well, thank you very much. We will reserve our judgments. We'll let you have them in the usual way in draft for typographical and administrative corrections. No further argument, as you appreciate. At the same time, we'll expect you to seek to agree a draft order, and if you can't agree, to make brief written submissions on the points on which you disagree, and we'll decide those on paper. It'll be handed down remotely, no need for attendance. You are, I hope, and I'm sure well aware of the restrictions that apply to the draft and how seriously they are to be taken in the light of the recent Court of Appeal authority. Thank you.